in an independent care facility. But right now I help take care of my great grandma, so it's just a lot at once.
So how do you support yourself? How do you eat?
I live with my grandparents and I help them take care of her. She can't take care of herself. She has dementia and a mental disorder.
Danielle Free. Miss Free, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On November 6, 2024, officers conducted a traffic stop on the defendant's motor vehicle after observing it speeding 55 miles per hour in a 40-mile-per-hour zone in the 7800 block of Spencer Highway. Upon contact with the defendant, the officer detected an odor of an alcoholic beverage on the defendant's breath, and standard field sobriety tests were conducted. HGN.
Let's talk about Danielle Free to open twisted tees, muscle relaxers, and a future in nursing hanging by a thread. This isn't just a DWI, it's a career-ending cocktail. The mix of alcohol and prescription meds raises major red flags. And let's not forget the optics. Open containers in both cup holders. That's not just bad judgment. It's practically a case study in what not to do behind the wheel. Comment below, if you were the judge, would you consider her nursing? License revoked already.
6 out of 6, walk and turn 3 out of 8, and 1 leg stand 3 out of 4. The defendant admitted to drinking and to taking prescription muscle relaxers on occasion. The officer located a case of twisted teas in the defendant's motor vehicle with 2 open cans of twisted teas, 1 in each cup holder. And
So consuming while driving?
There were 2 open cans in the cup holders, yes, Your Honor. And DICs were read and the defendant consented to blood.
Ms. Free, I'm going to find that there's probable cause to go forward with your case. I'm now ordering you not to drive. Do you understand? You are not allowed to drive any vehicle whatsoever for any reason. You will be signing an affidavit with me today, promising me you're not going to drive. If I find that you do, I will have a contempt hearing. You'll be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? I'm also ordering you not to consume alcohol or illegal drugs. You will be randomly tested. If you consume alcohol, illegal drugs, unprescribed controlled medication, likewise, you will go to jail. No more PR bonds. Do you understand?
Here's where things get complicated. Danielle just graduated from nursing school. She's not partying. She's caring for her great-grandmother with dementia. That context doesn't excuse the behavior, but it definitely tugs at the heartstrings. The court isn't just sentencing a person. It's weighing her potential to do good against a dangerous lapse in judgment. Would you show compassion here or believe consequences must come first?
Give you eyes, Alex.
No, Your Honor.
Any prior criminal history at all?
She has a prior racing on a highway that was dismissed earlier this year.
What do you do for a living, Ms. Free? Why?
I just graduated nursing school, so I was a CNA and caregiver in an independent care facility. But right now I help take care of my great grandma, so it's just a lot at once.
So how do you support yourself? How do you eat?
I live with my grandparents and I help them take care of her. She can't take care of herself. She has dementia and a mental disorder.
I'll fill out an application for you. I need to know everything about you, how much money you make, what kind of car you drive, any source of income that you have, money in the bank, stocks, bonds, IRAs. I'll have you fill out an application, but I need to know everything about you. Don't just put zeros because I'm going to send it right back to you.
Yes.
Do you understand? And I'll see whether you qualify. Above all else, do not drive. Do you understand? There's no justification that you can give for getting in a car. Likewise, don't consume alcohol or drugs. If you have a problem, you better address it, because if you don't, I'm going to do it for you. Promise you're not going to like the way that I do it. You understand? Okay. Do you mind giving me an application, please? Morning, Mr. Singleton.
Good morning, sir. How are you?
Doing great. You know, it's Thursday, Friday Eve. Ready for the weekend, you know?
Yes, sir.
So
See, you have decorations.
thanks. Well, it's all them.
Yes, sir.
Your lawyer has asked for me, or is asking for a bond reduction in your case, but you know, my concern, and I guess my very, very primary concern, is public safety. You've got a lot of serious charges. And from what I see, your bond.
And now we shift to Mr. Singleton to open aggravated assault cases, a previous family violence charge, and his team wants a PR bond, essentially a free pass out of jail. That's like asking for a job promotion after setting the office on fire. Even Judge Boyd looked stunned by the request when the bond discussion began. You could practically hear the courtroom exhale. Is the system too forgiving? Or is everyone just trying to give one last chance?
200,000, you've got 2 open aggravated assault cases, and you got an assault of a family member with us. Bond is set at 5,002. What did you guys want?
Possibly looking for a PR bond due to the fact that his other 2 cases are extremely high. We believe that he should be able to bond out on that. We have been talks. He has been in talks with some family members regarding possibly coming up with money for the other 2 bonds, but reducing it here would possibly help him out regarding the overall amount that he will have to come up with.
Well, so my concern is it looks like in September, he had an aggravated assault with a deadly weapon dismissed, right?
I believe that case got filed twice, and they.
So what's going on with the cases upstairs? And is it the same complaining witness as our case?
There's two complaining witnesses on those cases, Judge, and it looks as though it's a different complainant with us.
Is there a weapon involved? Is it a shooting?
On the aggravated assault with a deadly weapon, Judge, so in the felony cases, there's 2 weapons involved, a machete and a gun, a 9mm handgun.
Does he shoot at them? Does he shoot?
At them. So the state would be opposed to lowering bond, Judge, given the severity and the propensity to violence that felony cases also show.
This is where things go from concerning to chilling. A machete, a 9mm handgun, allegedly threatening to shoot someone in the head. Over what? A bush, a fence. This isn't just violence, it's neighborhood vigilantism turned into a ticking time bomb, and yet here we are debating bond terms. Drop your thoughts below. Should weapons like these be an automatic bond denial?
I think I remember this case. It's about a neighbor, and it's either about like a fence or it's about some bushes or some, right? So
The state's concern is community safety, Judge. So for those reasons, we would be opposed to lowering his bond.
Even if it's not going totally to a PR, if possible to do 2,500, that was great.
I don't know, you know, I mean, we gave you a PR bond in this case. I let you out, right? And then you go out, you allegedly have these now 2 aggravated assault cases where in one, you point a gun at someone.
Singleton tries to defend himself, claiming stolen property. But Judge Boyd cuts through the noise. There's a right way to respond, and this ain't it. The judge isn't just delivering justice, he's offering life advice in real time. It's moments like these that remind us this courtroom is more than legal theater. It's a place where lives pivot based on accountability. Are judges supposed to lecture? Or is Boyd just doing what most won't?
I'm in the head.
And if I remember, it's something so trivial over. Don't talk about the cases though, because I don't want you to.
I wouldn't incriminate myself or anything, but I live by truth, sir. And these people stole stuff from me.
No.
But Mr. Singleton,
Not that.
but there's a certain way when someone takes something from you. There's a certain way that you got to act.
I'm the one that
No.
called the police, Your Honor.
And that may be so, but there's still a certain way to act, right? And if you.
Washington?
Refresh my memory because I just don't remember it.
I can read.
Yeah, go for it. Just a brief synopsis.
On or about September 7th, 2024, complainant saw a
Shh.
in his truck when he was awoken by the truck and knocked off the window with a 9mm handgun. The defendant then pointed the gun at complainant Sarver and demanded that the complainant get out of the car. When complainant Sarver got out of the car, the defendant stated that he would shoot the complainant in the head. Complainant Sarver advised that prior to coming home from work and having his incident with the defendant, the complainant too was also involved in an altercation with the defendant earlier in the night. The second complainant stated that an altercation arose between him and the defendant, which resulted in the defendant punching the second complainant in the face, causing him pain. The second complainant punched the defendant back, and the defendant ran to his house. Shortly after, the defendant returned with a machete in one hand and a stick in the other, and was calling out for the second complainant to come out to the street. So it seems as though he pointed a gun at complainant 1, and then in complainant 2, he punched him, and then when the complainant punched him back, he came back with a machete and a stick.
Sorry, Mr. Singleton, it's just too dangerous for me, man. I can't give you a PR bond. I already gave you a PR bond. We'll let you out, and then you pick up these 2 serious cases. You know, if we give you a PR bond now, if we were to lower, I mean, what's going to happen? You're going to pick up a 4th case? We're trying to prevent that from happening, you know?
Order in the court. May I speak?
But not about the cases, okay? Just because I don't want you to hurt yourself, you know?
I understand, Your Honor, but I don't recall you ever giving me a PR bond, sir.
We gave you a PR bond on, in our case, we gave it to you on 8/12 of 24. I gave you a PR bond. We let you out of jail. You know, you had certain conditions that you're supposed to follow. No weapons, no contact with the complaining witnesses. And so here we are with 2 very serious cases. If you're able to bond out, and if you have someone, come back, talk, perhaps we can,
My fiance,
you know, but
the person who this is.
you're your own worst enemy, Mr. Singleton, really. I mean,
I'm
you're your
sorry.
own worst enemy.
I guess it's the military.
Well, don't blame it on the military. They're choices, right? And
Yes.
sometimes choices are made such that,
I know I need help, Your Honor. I'm not saying I don't need help. However,
the problem is that you can't do that after the fact.
I
You
understand.
got to recognize it before the fact, before it balloons out of control. That's why, you know, and it's not our first rodeo here with you. You've had prior assaultive cases like this. So you have to understand that when you get these feelings.
This might be the twist no one expected. Judge Boyd offers Singleton a path toward mental health treatment instead of immediate punishment. Despite everything, he sees potential for rehabilitation. But he warns, if you don't take this seriously, I will. This is a rare moment of humanity in a courtroom filled with chaos. Could this be the turning point in Singleton's life?
You're going to lose. You got to try to take care of this beforehand. Now, why don't we have him TRAS'd? Okay, let's see what it says. Let's see how to go forward. You know, if they say that there's treatment that's, you know, I have options available to help you with these issues. And I'm willing to help you and I want to. Yeah, we will do it. But the first things first is I got to have you evaluated to see how we go forward. And if you let me do this, and if you're honest with me, Mr. Singleton, let's try to work something.
I will be.
All right. Can you set up a TRAS for Mr. Singleton? Yeah, please. I'm going to set you for an evaluation. I'm going to have you speak to clinicians. Be honest.
I will.
We'll come back in a couple days. Today's what, Thursday? Come back on Tuesday. Let's talk about how we go forward. Okay?
Yeah.
Look, this isn't the be all end all, but let's see how we go forward. You know, that's why God put eyes in the front, so we go forward. We don't go backwards. All right?
Your Honor.
Okay. All right.
Thank you. Appreciate it.
Stay. Okay? You know, Alan, you know, depending on what that TRAS says, it may also help with what upstairs to try to work out some kind of treatment program so that, you know, because it's all just anger, right? Yeah.
That's the first time I've seen her actually. Like that, so it may be.
It may be worth exploring because it'll help, you know, hopefully upstairs as well. Yeah, thanks.
Yeah, what's your honor?
Mr. He?
Sir.
Good morning, Mr. He. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, sir.
Okay.
On November 11th, 2024, officers conducted a traffic stop for a defective license plate lamp in Harris County, Texas. The officer made contact with the defendant, the driver and sole occupant of the vehicle, and observed a strong odor of an alcoholic beverage, watery bloodshot eyes, and disorientation. Standard field sobriety tests were administered. HGN 4 out of 6. Walk and turn and one leg stand were not administered due to the defendant becoming belligerent. Walk and turn.
Mr. He stopped for a broken license plate light. But what began as a routine stop ends with him refusing to provide a specimen and becoming belligerent. Refusing a test in Texas often results in harsher consequences than failing one. His case shows how fast a minor stop can spiral. Real question, should refusal alone be enough to escalate charges?
Prior to termination, they had detected 1 of 8 clues. The defendant read the DIC and refused to provide a specimen. A blood search warrant was obtained and executed.
Any prior DWIs?
No, Your Honor.
Okay. Mr. He, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. We will randomly test you. If we find that you consume alcohol or drugs, you will go to jail. And that's it. Do you understand? Do you have a valid Texas driver license? Do you have valid liability insurance in your name? You may continue to drive as long as you have both, and Mr. Murphy will tell you if it does become suspended. If it becomes suspended, you may not drive. Now, because you have a lawyer, we will waive your appearance. You do not need to waste your time coming to court, but you must stay in touch with Mr. Murphy, and he will tell you if and when you have to come back to court. If he tells me he can't get a hold of you because you're gone and you're not responding, I will issue a warrant for your arrest.
That won't be an issue, Your Honor.
I don't think it will, but we have to put you on notice of what we expect and what what happens when you start acting up. So we will have you just sign a reset with Victoria. We'll have you get with Fleischer for your bond conditions, and then you guys are free to go. Okay?
Judge, thank you very much.
Guys, we're talking about Akin Pelu. Is he on the docket today or no?
No, you just want us to come back.
Let me give you a cause number, guys. And
I remember this case, Judge.
I'm at a loss of everything, you're on 2 different felony probations, both of those for driving while intoxicated. Both of those are felonies. So it's not only do you pick up 1 DWI third, but you pick up a second DWI third. Get on probation for both of those. And now you've picked up here, driving on a suspended license. We ordered you, number 1, not to drive, and number 2, not to consume alcohol. That's all I've ordered you to do. Just don't consume alcohol and don't drive. Has anything happened upstairs?
Well, Your Honor, to be fair, I think the integrity of the machines are in question. 11/7. So when he picked up the first one on 10/29, you told him to test Monday and Thursday.
You picked up what? The machine?
No, when he when you thought it was a tamper on 10/29, he started testing Monday and Thursday, which in this case helps us. So on Thursday, 11/7, he was here in court where he tested. He tested at 12 o'clock.
Here's where the courtroom gets tetchy and messy. One test shows tampering with alcohol. Another test, minutes later, says he's clean. The Scram device, meant to detect drinking, is now on trial. Itself, is it catching real violations? Or glitching, because if he was clean 5 minutes later, we might be punishing someone for a faulty machine. Ever wonder how reliable these court-ordered monitors actually are?
At 11 a.m., they got a tamper and a sign of alcohol. However, he tested clean with the test you told him to take that day. So which tells me that that machine's integrity is not correct. So if the integrity of, and he's maintained that he has not been drinking either time. Every time we did the court, I promise he's not drinking. So if that machine is saying tampering alcohol and he goes and tests on 11/7 at 12 p.m., an hour after the tampering in alcohol, and he may be telling the truth. And I understand what we're dealing with, but he has tampering, sign of alcohol, and then it dissipates and there's nothing there. So
I'm on the same page as you as far as I never want to punish someone
right,
who's never done or who has not done anything wrong. That's not, we don't do that. We're the exact opposite. I mean, I scrutinize every single thing that Michael does, every case, every probable cause, I don't think I scrutinize the hell out of it. But at the same time, I also do that with people that are in front of us as well as people with charges, right?
and Your Honor, and to say off the record, I know that you do that. I know that you are a judge that will be very fair in these situations. So I'm just saying that.
So he takes a urine sample. It looks like on 11, what day was it?
11/7.
11/7.
I think the sample was taken around noon. He did two that day, one upstairs and one downstairs. So 11 and 1 o'clock, he had to do two different samples. 11, I think 07, they say he tampers and a sign of alcohol occurs. So he was here in court, but still have two urine analysis around the same time as that he.
Alicia,
Yes,
do you
Judge?
have a test for 11/7? Because I don't have it.
Yeah, so it's probably not in those records because right now it's just presumptive. It was presumptive, but it's negative. So nothing came back. I have it on my end here. It should be.
What time was the positive for alcohol on 11/7?
For the scram report? Let me see.
I thought it was like 11 a.m.
Sorry, normally I don't look over those reports because I don't know how to use them, but I will try to figure it out.
And Judge, I might have an unupdated report. The only BVR I have here is for a scram violation from October 30th.
Yes.
Was there another violation?
Yeah.
Okay.
So there's a violation technically pending on our end because he was coming in that day, so I addressed the violation. And so they were waiting to file it to see if judge wanted that to be filed because he was going to address it at court. And that's what we're discussing from 11/7. So that violation is pending a DVR because judge is taking action on it already.
Do we have a,
I could have sworn you said that there's another presumptive alcohol
On 11/7.
on 11/7.
No, there's a presumptive negative for the POC test that he took, our rapid test.
No, yeah, right.
On
I know that
11/7,
one.
it was a alcohol detected, but.
What time was that?
confirmed- I'm trying to read the report.
Because
but I
that's,
don't know how to read
see,
the
we've got a
So I
presumptive.
got it right here for Brittany Gordon. The defendant order was to obtain a scram device. The defendant's scram device has confirmed one tamper event. The tamper event occurred at 11/7 at 12:42 p.m. Now he was taking the test at 12:30
Hold
p.m.
on. Saying it was 11/7.
At 12:42 p.m. Got this email on November 11th. It went to everybody in the court. And alcohol was detected during the tamper. However, alcohol cannot be confirmed as consumption because of the nature of the tamper.
It began at 2:25 p.m. and returned to baseline at 8:04 p.m.
Either he's got superhuman detox powers, or the scram device is glitching harder than a Windows 98 update. Even the judge can't help but crack a line here. This isn't just witty. It reveals how baffled even the court is by the tech. Evidence. Comment below. Are these devices justice tools or digital traps?
We also took another test with you guys on 11/7.
Yes, that was at 12:47, I believe. Let me double check.
What? So at 12:42, he tests positive for alcohol, and then at 12:47, he tests negative for alcohol. Am I right?
It was, sorry, one second. It was Tuesday, October. I'm sorry, Judge, respectfully, I have no idea how to read scan results and everything that's in my email, but I can check on the drug test for you.
Well, I can, so the 11/7, we have the email on November 11th, okay? Then if you go to the email she just sent me, it tells you when the lab test was submitted. Hold on. You just sent me this email. And this email from Average Size Individual Screening Report on 11/7, it says that it was, one of the collection times was at 12:08 p.m. on 11/7/12/24. He did negative. So that means while he was in court, he would have to drink. But then he took another test after that. I don't know what the other test is at. What I'm saying, Judge, I'm gonna say this whole, if we were in trial right now, the whole integrity of these machines would be in question right now, because in the previous test, because the same exact message that we got on 11/7 was the same exact message that we got on 10/29. Scram temper, alcohol cannot be confirmed, same thing. So what I'm saying at this point, he has maintained to me, and I know he's messed up.
Judge Boyd takes a pause to clarify something rare, his fairness. He emphasizes how closely he scrutinizes not just the defendants, but his own team. This level of transparency isn't just about this case, it's about public trust in the system. In a courtroom full of contradictions, Boyd tries to anchor everything with integrity.
Numerous times. He's maintained to me that he has not touched alcohol since his last situation. He did drive, he's wrong for that. But these new testing procedures that he's got, huh?
I mean, he did
That's
drive.
why we're in here, because he was driving.
So due to the charge though.
Yeah, he did drive.
I hope to God that you're not driving this driving.
No, I'm talking about due to this charge, while we're back in your court.
Okay.
Judge, I don't have any of those emails. I think the best thing at this point is we can set this off for a bond hearing, and I can bring Ronald Grant here to clarify all of this with all of us, because none of us are experts. We don't know how to read the report. I know what defense is saying, but I can't even tell you the veracity of anything that's happening because I don't even have these emails.
Yeah, so
I can subpoena Ronald Grant. We can do this next week. I can get it done.
let's not disrupt other people's lives. It's
Sure.
not necessary.
Sure.
He is saying that we have a test, and I mean, what Mr. Evans is, test 11/7, the scram at 12:42, there's a positive, but then 7 minutes later, there's a negative when he goes up there to test. The machine's obviously messed up if that's true.
Is that what you're saying, Felicia?
And then I've also noticed on the scrim report, I asked them, because again, myself, I cannot acquire this, I have to have it provided from our case managers and the provider of the device. But the scrim report, the only one that I'm seeing attached to the email is for the DVR that was filed for the 29th, but I'm not seeing the one from 11/7.
So we don't have a scram report from 11/7.
We have an email.
It's not attached in the email, but we do have the rapid test when he was on site.
The rapid's negative.
Yes, and then we were informed, like I informed you yesterday, of the pending BVR violation for the 11/7
Hold
at that time.
on. So Judge, we don't even have the scram report. We don't know what the presumed blood alcohol content was. It's very possible that if he had a very low blood alcohol content or breath alcohol content, that the scram detected that he could have come to court, taken a test and gotten a presumptive negative, because it's already been eliminated from his system. That's why I'm saying I believe we need to get that scram report from 11/7, get what the tamper is, have Ronald come up here and tell you what's possible or what's not possible, because he's the expert, and I get what defense is saying, but he doesn't know either.
But
I don't think-
let me respond to that. What we do have is a test that happened at 12:07.
Right.
And I can show you that one. So even if we don't have the one that she spoke of at 12:47 that she referred to, we have a test right here which will make us have to believe that while in court, he drank some alcohol if these machines are deemed to be valid. And we were about to reprimand him for the 11-7 situation, but now it's time to.
Reprimanding or remanding, he's suggesting that we just do it at a later time to get everything all together.
Okay, well, in the meantime, since these machines.
I'm not gonna take him into custody until I know 100%.
But can we, because he's working, he's come here. The reason why you put him on Monday, Thursday is because these tamper going down. So we're gonna wait to see if these machines are valid. I'm requesting that we go back to the same bond conditions that we had prior to the tampering. So he does not have to miss work twice a week, coming out here and testing, because all we know, this could be a big mistake.
And I would strongly object to that, Judge, based off what he's on.
The defense wants bond conditions rolled back because the testing devices might be faulty. The prosecutor says, absolutely not. We're at a standoff. The judge walks a fine line. He won't jail him yet, but he won't loosen the leash. Either. Welcome to courtroom limbo, where tech failures and legal stakes collide. What would you decide here?
Probation for right now.
Well, but the only reason why we're doing the twice testing is because of the tampering. So if the tamperings are invalid, why are we doing something extra when that wasn't what the judge originally wanted?
Well, because there's an allegation right now. We need time to confirm or deny that. But for now, the safety of the community warrants these bond conditions, in my opinion, Judge.
And I strongly disagree.
Mr. Evans, we have a curfew on, right?
I don't think we have a curfew. We just have to scram. You just have
He
to
has a
scram.
curfew, Judge.
Well,
So,
seven, okay.
so,
Are you working now?
yes, sir. Working with a hospital in, I have a project with Epic. So I assist physician and nurses on the software they use called Epic. The software is called Epic.
I don't want anyone to lose a job. I mean, the last thing I want is someone to lose a job, right? But I have to know that you're not drinking. I can tell you. I know that you tell me no, but all I have are consistent problems. Every time we had you on docket for whatever it may be, there was always problems. Every single time you came in here with the DWI, there were issues. Every time you came in here with the suspended license. And I'm telling you the history that we have,
Understand.
you know?
Understand.
So that's why it's hard to believe all these coincidences when the nature of my relationship with him was every time he had a case, there was at least 3 PVRs. Every single.
And I was on your side. I was completely on your side. I thought.
The judge drops the truth bomb every time this man has had a case. It comes with 3 bond violations every single time at some point. Coincidence becomes pattern, and the court sees it. When history repeats this clearly, even the most hopeful defense can't argue credibility.
He was telling me not the truth, but once I saw that he was in court that day.
Let's do this. Let's set it for next week. Let's get every record, subpoena the person, right?
Can we do next Friday, Judge? Is that possible? I'll be in trial next week till about Wednesday. Can we do next Friday? Okay.
Or not Friday, Thursday? Or, okay,
Friday's okay. Yes, Judge.
yeah, and do you want me to waive the appearance?
I just want you to waive the test.
Oh, okay, I will.
Yeah.
I will.
Yeah, that's all I want.
He's got to be here for the next PVR here.
No, yeah, that's fine. Yeah, I just want him to be able to work. So thank you so much.
I'm tired of having to deal with one problem.
Finally, Judge Boyd closes with a no-nonsense directive. Get a new device, period. No more excuses, no more confusion, just clarity. And in that moment, you can feel the courtroom exhale. He's not just demanding compliance, he's giving this defendant a fighting chance. But the next mistake, it'll be the last one he tolerates.
One or the other. I would suggest that you go get a new machine so that we know that there are no more issues. Go down there, tell them, hey man, give me a new machine so that we know if there are any issues, that way you can make sure that you get a new one. Felicia, can we send him for a new one now?
Yes.
Just to make sure that, Okay, so you guys pick it, we'll do it. And then we'll do it. We'll take them off that.
Thank y'all.
Yeah, we'll stop for now. Yeah.
So you sent the test upstairs, right?
From nursing careers in jeopardy to machete assaults over neighbor disputes and mysterious SCRAM test results that almost sent a man to jail for something he may not have done, today's courtroom gave us everything. Judge Boyd was equal, parts enforcer and educator, drawing hard lines while still offering second chances. But in every decision, one thing stayed clear: public safety comes first. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Until next time, stay sharp and stay informed.